Hello, everybody. Long time no see. I have missed you guys a lot. For those who have, if you don't check community post, which I totally get and understand, that was always hard for me to remember to do or go look to do. But um, I have had a massive delay in live shows. Although I tried to keep stuff going on with some clips about facts for everybody for the Delphi, which I haven't done all of them, but I've popped out a bunch of them for questions that are always out there about um, Delphi and stuff I hear people talk about, right? And it's like, no, that's not what happened, or we know better about that. So, um, but there has been um, a lot going on, and I guess from that stuff, I will just say to all of you guys, I hope you all are doing well, and I hope that you guys all make sure to take care of yourselves and, you know, make sure when you're following the true crime community and hear the stories and everything like that to make sure that, you know, you take a break for the fun stuff and the laughter and everything as well, because that can really get to, um, can get to us. So, um, and I see French is out there and Silas Singy and of course Jinx is out there. I just love all you guys. Like I said, I've missed you. I had some testing, as you guys always know if you've watched my videos and been around, for heart stuff that ended up bad news. And then we had a unexpected death in our family that took all of us by surprise, and um, it was just hard. So, so I hope you're all well and appreciate each other. And you never know how much time you have with anybody, and you never know what can happen. And so, I just want to share that. I'm almost have been out of here so long. I'm almost a little bit nervous to get started all over. But oh my gosh, while this has been going on, if I don't have a live up or a video drop, I am always posting in the community posts. So if you go into the YouTube channel, if you're not used to doing this, if you go under community, you'll see I drop document copies in there, which, by the way, YouTube does not make that friendly. I know a lot of people are like, oh, well, put it this way or do it this way. YouTube doesn't make it easier. Because normally if you're dropping it like images, and it only lets you go up to 5 when you do that. So once I'm able to create a file that I can just drop the PDFs for you and create all that, I will do that for you. But right now, the way it's set, it only allows to drop the images. So that's why you'll see in the post, if it's more than 5 pages, I will put in there it's one of 2 or one of whatever, and keep you up to date. But yes, a lot of my clips that I've been doing for you guys have been facts that are out there that we know about, or maybe sometimes there's a couple I know out there where I ask the question. One of my questions that I recently did that I put out there as a YouTube short that wasn't a fact was to ask everybody else. And that is, what is Richard Allen's alibi? I think that's a good question. If he didn't do it, then what's the alibi? And I don't think that's ever really been out there. So, yes, thank you, French. Yes, Jinx, I've missed you too. It has been really hard. And I really do appreciate all of you guys. Hello, Phil Bond. How are you? Wow, it's so nice to. Hi, Simon. West Yorkshire. All right. Well, I wanted to go over a few things in here. And I thought I would start with, I think, the most important, obvious stuff here. And I'm going to go ahead and just do entire screen so that way I'm able to show you exactly what I want to here. And that one's going to be, let's see. Which one would I like to do first? Let's do this one. This one's a nice, this one's a nice, short, sweet one. So this document, these are all the responses from Judge Gull, right? And I first thought maybe she'd take a little longer because she would have up to 30 days to respond to it, right? And I thought she may like drag that out because then, honestly, then it holds off that the defense really can't file anything, right? Because when they file stuff, they're saying you can't respond to this because you may not be the judge when you disqualify yourself. Okay, nobody who believes she's going to disqualify herself. Honest to God. Give me a break. So, let's look at that one first. So in the disqualifying document, this one's a nice, short, and sweet one, guys. So the court reviewed the defense's counsel's petition. This one was to strike her comments. Gratuitous and demeaning commentary and or findings from the contempt order filed on May 8, 2024. As the court granted counsel Hennessy's motion for specific findings of fact and conclusion thereof, filed on March 2024, this motion is denied. Well, that's nice and short, don't you think? I think that got to the point. That's pretty much, I don't know about you, but Hennessy's not rubbing me the right way whatsoever in what he's been doing and how he's been with some of this stuff. But let's look at the this other document now too. And I'm going to go ahead and pull up her response to disqualify. I expected it really to be longer. I really did. But she was pretty, short and sweet to the point on this. So the court reviewed, remember, this is the second verified motion to disqualify. And can I point something out? They keep saying, oh yeah, Jinx, we're going to be talking about the money. That's for sure. I want to talk about the money because I think they misled people about the money. When the defense keeps saying that they are filing because all of the things they keep filing, basically she's not approving, right? Well, what the hell? They're reapplying the same shit. How many Frank's hearings are you going to file to know she's not going to throw it out, right? I mean, that's like when you read the document. I was so amused. I read the document where it says when they asked for the second statement, the second interview, which is meaning the interview they had when they called him into the police station on the 13th, confirmed his story, that he told Dan Dolan, and then confirmed additionally what clothing did he have on, all this kind of stuff. In addition, he confirmed then what he was wearing, which was not part of the Dan Dolan interview, right? So they were like, they filed this, and what do they say in there? They go, they only want this, discounted. That's not true. They actually want the first stuff that they also had disqualify out of there, because they want that there is, the Franks hearing itself would take out everything. They don't want that interview, that second interview and stuff like that. That's like them trying to say that when he was called in October after the search warrant, and they said police officers lied to him, and he was, now I get people arguing, oh, well, that was just for him to come pick up his car. Okay, here's the thing. We know police officers can lie to you. But guess what? They didn't lie to him that you're coming in and you're picking up your car. That's a common thing. Have you heard about the ones when they tell people they won the lottery, but they're actually wanted, and they go in there and they go to try to pick up a prize or money or whatever it is, and guess what? When you get there, you're actually arrested, right? You're arrested when you get there. That's like saying, well, they pretended to be a prostitute, and when I went there to the hotel to be with the prostitute, they lied to me. They were not a prostitute. Give me a break. I mean, I know I'm going off on this little side tangent before this document, but the obvious point is they did not get the car that day. What did happen on that day? This was within about 2 weeks, less than 2 weeks after they took the cars and the stuff from the house and everything from it. They did that on the 13th. The 14th, at the Lafayette office for the Indiana State Police, they removed the carpet and stuff from the car, marked it to be checked in a lab. Within 2 weeks later, they arrested Richard Allen. They did not arrest Richard Allen because he said he was there. They did not arrest Richard Allen just because he says he wears blue jeans, right? They arrested Richard Allen more than likely because he sat here and they probably had some lab work that came back in. On the 13th, they took his DNA off the water bottle. And then on the 14th, they sat here and they took the carpet from the trunk of the car and the swabs that came from the seat belts and from the passenger side flooring. This is in my opinion. I know there can be what's called a fast DNA test. Lots of times they do that. Those fast DNA tests actually can come back within, 24 hours. But this is a lab work test. So a lab work test can take a little bit longer. But after they did that, then they called him in to be arrested. They did not return the vehicle to them when he came back in. So I just got to say that. I know I've had many, many comments of people saying stuff to me about some things, and I'm just telling you. So when they look at this, when she responds to this, hey, have her removed kind of thing, and they ask about the request of, the findings, to request if this court denies this report filed on May 17, 2024, says as a trial rule 52, it is not applicable in criminal cases that the defendant requests for findings of fact and conclusion of law is denied. And then they state the Indiana state law for that. The court, however, will address each of the defendant's allegations in this order. So the defendant claims that the court directed the Carroll County Sheriff to ignore a subpoena and that the court directed an email to counsel on June 14th of 2023 regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested the report of the witness refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court. So the defendant claims that the court engaged in ex parte communication with the Carroll County Sheriff regarding the defendant's housing, transportation, and safety during the jury selection and trial for May 13th or the 31st of 2024. These communications were administered in nature and did not address any substantive issues. The communications were directed where the defendant would be housed during the trial and who would be conducting the transportation. The court did not notify counsel where the defendant would be housed during the trial, as he still is under the safekeeping order, in an email, but did not inform counsel of the communications, as nothing substantially was discussed. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel the hearing upon the filing of this pending second verified motion to disqualify. So just to be clear, as we said in the beginning, they asked, the difference between the first time they asked the motion to disqualify and the second time is because they requested for the findings. And that's what she's trying to say to them at the very beginning of this. Well, she doesn't have to find that by in there, but she is, right? So, but they're sitting here and now they want stuff done. That's like asking for a speedy trial, but yet they hadn't filed it. They filed it with the Indiana Supreme Court that they're not getting a speedy trial, but they didn't file it. Richard Allen wanted that 2 months prior. Even the Supreme Court asked them, you have this from your client. Why have you not filed it? And they were like, oh, this is part of our strategy, blah, 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 blah. Well, no, you didn't. And I'm working on a video. I'm going to go through I hate to call it timeline because it's not really time, but a bunch of gathering together all of the information and stuff under Richard Allen of stuff that we know, what happened when he went to court, when he said what, who he was interviewed by, when he first went to Dan Dolan, all of that together. And put that all together with other stuff that we know. And part of that is going to be about all of the confessions that he has made, the timing of that, when he was put under suicide watch, when he first started confessing, when all of this was going on, what were the other things going on that we knew at the time, but we didn't know what was going on in the background, right? And putting that all together. And part of that for me is going to be, does Richard Allen just want this over with? And if he does, and he just wants to confess, I'm saying if, for all the people, I understand people think different directions, but if he does, I have I have more, I don't know how to word it. I just don't have faith in his attorneys. I'm just going to say that. I think some of the games that they have played has been awful. And then at a certain point, are they going to do what's in the best interest of their client, Richard Allen? Or is it going to be more of what type of publicity, which they're getting, what type of publicity are we getting, like a Jose Baez or the Dream Team, right? If Richard Allen wants to sit here and he does want to confess, maybe he sees the evidence that's against him. Maybe he knows that there is some solid forensics that's in there. And that's why he decided to go ahead and tell his wife and his mother, which I think would be, wouldn't that be like the ultimate, I don't know. Wouldn't that be like the ultimate, like, last people you would finally tell? I mean, if you did something and you finally admit it, wouldn't that be the last thing you would say? And you would finally admit to? And he tells his wife, he tells his mom, he did this. And if Richard Allen wants to make a deal, and even let's say the prosecution comes and says, we'll make a deal. But and this is what I think, and I'm really pissed because there are some plea deals, and I've posted some cases recently that people have made plea deals and we have not got information from them, right? That's like Valerie Tyndall's case. They got a plea deal. He didn't have to come clean about what has been going on and what he has done to that teenager for probably years. And that's bullshit. It's like the Amaya case. They have the boyfriend makes a plea deal, the mother makes a plea deal, and they don't have to say where they buried the baby's body? Right? I agree, Jinx. They don't, I don't think the ego, at least of Baldwin, would allow Richard Allen to make a plea deal. But if Richard Allen wants the plea deal, he wants it over with, he doesn't want people to go through trial, he doesn't want to sit there and they sit here and try to put him. I mean, here's the thing. One of the things that the attorneys kept saying was, before everybody knew how many confessions there were, at the time we only knew like 5 or 6, right? We only knew, like, the warden, his wife, his mother, right? We knew about those. But then we didn't know how many. And then they're complaining about that people are yelling at him and calling him a child killer in prison and saying that to him. Well, he's confessed. He's told a bunch of people. So I'm sorry, when you go to prison, that crime is the worst of the worst. If you have sexually assaulted children and murdered children, that's the worst of the worst. So, but if the prosecution said, we're going to come forward with you, we're going to give you a plea deal, we'll give you a location, maybe that your family can visit you easier, not send them out of state or whatever. But you have to come clean with everything, any involvement. How was it set up? What went on? How did you get a hold of her? How did you know they were there? Was there anybody else involved? And you've got to tell all of it. I mean, I don't know that they would do it. I really don't. So, in this information about to disqualify, court invited the state to limit defendant's Sixth Amendment right to present a defense. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counselor of their obligation to follow the law in the court's email on April 28th of 2024. And, again, she keeps pointing out that they had to cancel this out because they've done it a million times. Remember, this whole mess started at the beginning when they started filing a whole bunch of stuff, when they were asking for bail, which, I mean, when you're charged with murder, bail just doesn't happen in Indiana. When they have good evidence, they don't let you have bail. It just doesn't happen. Yeah, Phil, I wouldn't lie to my mother either, and I definitely wouldn't lie to her telling her I committed a crime if I did it. So then she replies about the counsel claims the court disparaged them and ruled on defense pleadings without hearings. The court's comments about the counsel's performance was documented in the court's order on April 30th of 2024 regarding the handling of discovery materials. If pleadings on their face are not supported by the law, admissible evidence, judicial economy does not require a hearing. Allegations that the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18, 2024 hearing. The court has notified on May 20th of 2024 of an inquiry by the Indiana State Police to the court reporter via email on May 9th of 2024 regarding ex parte communications received by the court from Gary, well, we know that's Fig, which was previously provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation. Defendant blames the court for ex parte pleadings, which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as confidential, apparently unaware that the confidential marking makes them available to the state, but not to the public. So counselor staff contacted the court staff and were advised that the statewide Odyssey case management system, not DocsPop as alleged in the pleading, has a distinct process for filing pleadings ex parte. I went over this and I had the information that I showed on one of the shows, that I have the instructions on what the courts do in filing and using that system. and how they mark that system, because we've had that before. Just like when they released information, the defense released information, and they did not decide to redact witnesses' names, right? Teenage witnesses' names and other witnesses' names from it. And they did not redact additional info. It was because of the way they filed it and whose responsibility it was. So I got that document of what the process was and what people have to do, what they do in drop down boxes when they're filing the documents, and all of the procedures they have to do. That means this does go to the public, it doesn't go to the public, it's redacted. That whole thing we've already talked about. This here is exactly saying the same thing that we talked about before. Hey, CJK. It's good to see you too. So again, they have something filed and they're going to blame the courts for something that they mark. It isn't what their court reporter marks. They file it. They drop it in. That's how it works. So since Stack Communications defense counsel have had no issues with their staff properly filing ex parte pleadings, accusations of violating rules on access to court records has been completely explained and dealt with, including by the Indiana Supreme Court in the first writ of mandatum files by defendant. Counsel claimed that motions are treated differently than those motions filed by the state. The court has set hearings on pending motions, which have now been continued due to the filing of this motion to disqualify. When defendant file pleadings, the state is entitled to file a response. The court follows the trial rule 6 regarding the time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's response. Once the issues are closed, if a hearing is required, one will be set. Defendant asserts that the court ignored his request to set aside 2 weeks for the defense's case while refusing to set time limits on the prosecution. Okay, my God, this is ridiculous shit. This is so ridiculous. So I know there wants to be people who wants to argue about this. Okay, I get it. Here's the thing. The court date and the amount of time had been set and reset and rescheduled and moved and moved and moved. Then it gets moved up. Why did it get moved up from October to our February date? Because they, after all the shit saying at the Supreme Court that they did this and wanted a quick trial, then they finally filed it. Not right away, but they filed it. Now, what I keep hearing on the other side was the reason this was also done is because the defense thought they were going to catch Judge Gull off guard, which I still don't know what that meant. I'm not sure what they meant by that. What would she be caught off guard for if they do an early trial? And then there was also, they were going to catch the prosecution. Well, I don't know about you, but the prosecution was ready. So it was the defense who we knew they kept filing and filing and filing, and nothing new. Hey, Frank's hearing number 20. I mean, it's like, It's like the Mission Impossible movies. Come on already. How many are we going to have? Give me a break. You filed a million francs hearing because, my God, they want that when they talk to him on that day, he additionally confirms when he's sitting there with them, he goes further than the Dan Dolan. He talks about what clothing he has. He confirms he has a jacket that matches the thing. He goes into all that. So why do they issue that search warrant on that day? Because he reconfirmed the Dan Dolan and went beyond that. And now he knows that he's a suspect. Remember, they didn't find him October 13th. Allegedly, which I kind of have some doubt on, but allegedly it's an Orion system, right? I think it's a tip. And then they looked at Orion system and found he was there. That's my opinion. But September, they had it in September. So they had weeks to check. They were checking something. They were looking into stuff when that was going on. By the way, during the water search, still while the Wabash River water search is going on. Right, CJK, a trilogy. So they're accusing them of all of this crap about the trial, of all of this date, about not giving them enough time. They never said a damn word about it. Remember, at this time, they're still trying to get funds for their expert witnesses. At first, everybody heard, oh, well, they're working, they're barely making any money as this, and they're not getting reimbursed. They're paying money out of their own pockets. And I will be going through this piece where she addresses that and showing you a news clip about this. And then it was, she's not approving expert witnesses. Well, if you're still getting expert witnesses and you haven't even secured them, how are you ready for trial? It's just games. It's just freaking games. So on March 6th of 2024, defendant files motion for a speedy trial. Not till March 6th. This year. The court granted that motion on March 7th. They set the case for a speedy trial in May, right? That was the May 13th or the 31st. Sorry, I think I was February. I was talking about a totally different date, court date. So they set the speedy trial for May 13th through the 31st. Then on April 30th of 2024, April 30th, the defendant files a motion for a pretrial hearing, which the court set for the hearing on May 7th. And at no time prior to the May 7th of 2024 hearing did the defendant advise the court that 3 weeks for a trial was inadequate. At no time prior to May 7th of 2024 did the defendant indicate a belief that 3 additional weeks could be added to the trial without notice to the court, witnesses, and more importantly, to the jury. Right? They already questioned the jury. They sent the stuff out. They knew what time frame they were going to be given. So now she couldn't do anything about it. So while the court agrees a continuance of the trial is harmful to the defendant and the state, it could have been avoided if counsel communicated prior to May 7th of 2024. Who was surprised they continued this? Nobody. Everybody kept saying they were filing so much stuff. We knew they were trying to do that. It was, well, we don't have this and we didn't hear about this information. And oh my God, there's so much evidence we got to go through and there's so much paperwork. And they filed this and they have all this and we just got notified about this. It's just crazy. It's crazy. So nobody was surprised. We talked about that even before here too. So a counsel asserted that between all defense counsels with a combined 70 years of experience, that not at one time had they been told that a trial would absolutely end on a certain day and not go any longer. It's irrational and unreasonable. The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. The court is not required to guarantee equal time for both the defense and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their cases, however long it takes. Had counsel notified the court within days of receiving the March 7, 2024 court order setting the case for a speedy trial of May 13th through the 31st of 2024, that the time allowed on the calendar was insufficient, the court would have immediately, where did I just go? I rolled it up and then immediately rectified the situation and extended the trial date May 13th to June 14th. Trial is now set for October 14th through November 15th of 2024, as requested by the defendant. We're back on the original date. I knew, and now mind you, it's longer. I knew we'd end up back in October. I thought they should have kept it where it was anyway. Counsel accuses the court of engaging in extrajudiciary activity. Now, this is about a Facebook post, right? They addressed this. Counsel is correct that on July 9th of 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. So her granddaughter. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about the team winning the tournament. If counsel's allegations is this part of their motion are well-founded regarding a potential witness, alleged social media activities, and are presented to the court for ruling, the court will rule accordingly. Concerns about anticipatory rulings are not reasonable. Defendant asserts that the court has denied reasonable request for funding. Okay, here we go. Here we go. Her response, first sentence, this is incorrect. Counsel is well aware the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to for $26,000 for investigative services from June 4th of 2023 to October 16th of 2023 was in fact returned to counsel as no documentation was provided for services. No documentation was submitted until quite recently. With that proper support and documentation, the court authorized that invoice for payment on May 17th of 2024. Okay, so let me show you this. All right. Of course, it's going to show another. Oh, you know what? I'm going to stop. I have to double check I have the sound set up here. Let me double check. Okay. And all right, so I'm going to share this here. This is from Channel 13 News. And one of the big things is after the hearings, part of the stuff was prior to the hearings that they had in regards to the attorneys and whether they were going to be found in contempt of court. There was a lot of talk about they're not getting funding. It's not a fair trial for Richard Allen. There was a lot of stuff going on. And then Hennessy on his own sat here and was doing a lot of this. Obviously, you know, he created the fundraiser, right? We know he did that. Well, and I think I'm going to show this in the I'll show another video, I think, and maybe I'll show that in the Richard Allen one that will be coming up. Here's the thing. There was a very weird thing that happened here locally. There was a couple YouTube channels who even caught onto it because there was a couple, not all, media who did it. One was a news publication, and then there was a local news station. One of those was that all of a sudden, Hennessy sat here, and it was released like there's going to be a gag order, another gag order issued by Judge Gull. And that was kind of like the headline of this. And then it said, but it doesn't include Hennessy. Okay. And to make sure if you're new or don't know, Hennessy is the attorney that Baldwin hired. And he's the one that represent him and Rosie for the contempt hearing. But he's sitting here putting his face forward in this. So all of a sudden, at the same time that this funding stuff is going to come out, there's this weird thing that is one news channel opened it up with a story with that kind of as the lead. And then there was a newspaper that did it. Couple people picked up on it. And Tennessee's like, oh, there's going to be a new gag order issued in the DELPHI case, or another gag order issued in the DELPHI case by Judge Gull. And then he was pointing out, but he's not under it. And it's like, well, wait a minute. Anybody who knows, she doesn't have to reissue another gag order. There is a gag order. There isn't like suddenly expired, right? So, yeah, that's Baldwin and Hennessy, by the way. But, oh, you mean in the news clip? Oh, I don't know. Channel 13 may have picked it up or whatever. But so all of a sudden, these things are interviewing. So Hennessy's using this to go get interviewed by people. Well, I didn't release anything about that because at first it didn't make sense to me that you don't have to reissue a gag order. Why is this coming out like that? And then I kept checking the My Case, kept looking at the My Case Indiana, right? Yeah, because Hennessy has a record on that. I don't know if you know about that, but CJK. So there was never anything issued. Nothing was filed and stuff in there. So there was some other places that took the info down. So, but it was giving an opportunity for him to go speak about the case and let people know that he could go speak about the case. So I found that a little odd that the lead in about, oh, there's going to be a new gag order. It covers everybody, but it doesn't cover Hennessy. And then Hennessy's out there speaking about this. They have him in there. Some of the stuff pulled back from it. It was never anything issued. You know why? Because you don't reissue a gag order. A gag order is a gag order. The only thing you would hear about is if she relieved the gag order. It's in place. You don't have to wait for it to be out of place, right? So let me just play this little piece here for you. And CJK or Jinx, let me know if you can hear it. Okay. Maybe not.
To paying defense experts out of their own pockets.
Let me go
And he
back
says those
here.
personal
Sorry.
expenses are getting to be too much. Hennessy says defense attorneys Brad Rosie and Andrew Baldwin have had to resort to paying defense experts out of their own pockets. And he says those personal expenses are getting to be too much, which is why they're now asking members of the public to make private donations. Now, if public defenders believe they are being denied funding improperly, they can always take the case to the Court of Appeals to ask appellate judges to intervene and order more money for the defense. But that kind of appeal takes time. And David Hennessy says they don't want to delay this trial months.
Do you hear that? Now, I said that back when I posted it back then. I posted it in a community post even, where I said, okay, if they're being good attorneys for Richard Allen and they believe that she was not approving expert witnesses unfairly, if she was doing that unfairly, then they could file with the appellate court. I showed a total different video back then of another news interview with an attorney who was talking about that back then. They could file the appellate court. So what did you just hear and what did you just see? There's Hennessy saying that the Baldwin and Rosie are not being returned funds. You just heard what Judge Gull said. They weren't given funds because they were not filling out the documentation and providing what stuff to be reimbursed. It was given back to them for them to get together and put their shit together. Guess what? That $26,000 that they kept talking about that came out of their own pockets did finally get reimbursed. They finally did bother to give the paperwork and stuff for it. And it got paid May 17th. But according to them, remember these attorneys who also said they would work pro bono, right? They would work pro bono. They sat here and were talking about that they were concerned about Richard Allen's trial. And he said, they could, this even reporters telling you, They could appeal it. They can go to the appellate case. And what does Hennessy say? Well, they don't want to delay it months. It would take months for the appellate court to get happen. Well, what the shit did they just do? They just delayed the trial months. And I don't care if they do delay. They're not worried any other time of delaying the case any other time. So why would you not delay the trial if truly it's the truth that she is denying you these expert witnesses? Then why, for your attorney's sake, would you not make sure they follow the law? You filed the appellate, and the appellate court would make her fund reasonable expert witnesses. I mean, give me a break. So they went out, they funded. At first, they were saying how they're paying money out of their own pocket. And that's really what the first part of this came to, because that's what the first part of raising money was about. They're paying all of this out of their pockets. They gave the impression that it was expert witnesses, and in what she just wrote, it wasn't expert witnesses, it was their investigative work. They got that $26,000. So they didn't file that. They didn't file it right. They got reimbursed. And that is why she's sitting here saying what stuff they're saying is incorrect. So did they mislead people? I mean, they're worried about a speedy trial. They thought that we don't have time to do a speedy trial. We need the money right now for these expert witnesses. We don't have time to ask the appellate court to make her follow the law. Bullshit. Then you know what? Then they shouldn't be Richard Allen's attorneys. If she is unfairly, if Judge Gull is unfairly actually not approving witness people, expert witnesses, why would they not find in the appellate court? I'll tell you why. Because I bet you money that it's because she has been approving reasonable witnesses. So, you know, I don't want to ever think that people are taking advantage of. No matter what side or whatever you're on, people work hard for their money. Times are hard, and you shouldn't take advantage of people asking for their money. And then they went over $40,000 has been generated by Hennessy. It's going to Hennessy. And that's what you see online. Remember, they encouraged people, if you don't want to pay the extra fee that uses that Go, the funding platform they're using, then you could mail the checks directly to Hennessy. So how much has that been sent in? So let me finish showing you this, and then I'm going to show you how you can actually support Abby and Libby and actual victims. Defendant complains that the public's confidence in this case has eroded. As counsel should know, criminal cases are tried in the court of law and not in the court of public opinion. Amen. An independent judicial court requires that judges decide cases according to the law and facts without regard to public clamor or fear of criticism. The court continues to receive a parte communication from the public criticizing the court both personally and professionally, and threatening the court with bodily harm and injury. And the court continues to provide these communications to the parties. The court is not interested in memes and other social media content that can be easily located on the internet. Paragraph 129 of defendant's second verified motion to disqualify. The court cannot be swayed by inappropriate and ridiculous outside influences. I am shocked by some of the people who want to continue disturbing this case, and they write letters to the judge and other people calling her names, calling her all kinds of crap, saying their opinions. Give me a break. It's just crazy. It is crazy. I'm you know what's sad is because that's like if you people who work in customer service or anything like that, you never hear the people who say, they don't hear people say good job or whatever, right? They only hear the people who bitch about them, and they bitch the loudest and are the harshest. And God, I'm hoping that they realize there are some sane people in the world who know that they've got to sit here and follow the law. The defendant further claims that the court has refused to order the state to comply with discovery rules. The court has set defendant's motion to compel and motion for sanctions for hearing. Wow, why is that running low? Hold on one second. Let me make sure I'm still plugged in like I'm supposed to be. I mean, I would keep thinking that that's the worst I could hear. That's the most I'm going to be shocked. And then something else happens, right? It's like, oh no, this can't get any worse. And then it does. It really does. Sorry, I just need to make sure this oh, that's why. This could be why. But I mean, I don't know if you guys have read all the letters. I mean, I don't post all of them because I think they're ridiculous. But some of these people's letters to them, it's like, do you think she gives a shit what you think? You think you're going to write a letter and somehow suddenly she's going to go, well, I got this letter from a no-named person and threatening me and saying that I'm being questioned as a judge. Well, let me change all my rulings now. Give me a break. Sorry about that. She says that the compel a motion to sanction for hearing, which has been continued due to the filings of this motion to disqualify. The previous defense motion to compel was denied without hearing as it was unsupported by evidence. Defense counsel alleged bias of the court, only allowing cameras in the courtroom on one occasion. The court has allowed cameras in the Carroll Circuit Court due to limited size and layout. The court did allow cameras in the Allen Superior Court at the hearing conducted on October 19th, 2023. The hearing was not conducted, and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in the ability for the media to cover hearings appropriately. The court has issued adverse rulings against the defendant as well as against the state of Indiana. Adverse rulings do not support a reasonable bias for disqualifying the court's impartiality, nor are they grounds for disqualification. They are just adverse rulings, right? Defendant's second verified motion to disqualify judge and request for findings of fact and conclusion of law upon denial of this request. If the court denies this request, the court denies, period, and this request is denied. Bam, right? I'm surprised she doesn't put cuss words in it, because boy, I'd be cussing. It's shit that they do. So let's look at the stuff about what you can do to support. So we showed that. First of all, the ride for Abby and Libby, the memorial ride, is coming up this Saturday. You can still register to participate in it. And you can go to the actual Abby and Libby memorialpark.org. And if you cannot participate in the ride, up in the upper right-hand corner of their site, which I'm showing you here, does have just a straight out donate. And $40,000 was raised for the defense in what I believe was misleading information. They told people they were not being reimbursed their expenses and it was coming out of their pocket, not telling them that the judge had said they didn't provide the proper paperwork or receipts or anything for it. They just finally returned it, and they just got reimbursed their $26,000 that they were telling you that they didn't get. And they're telling you about witnesses, expert witnesses, that they were trying to do a speedy trial for them, so they didn't have time for them to go appeal it. So they asked you guys for funds to go and donate so they could get these expert witnesses in time to have a speedy trial. Well, guess what? They didn't have a speedy trial. They delayed the speedy trial because they never decided to say anything to the judge about how long of time that they wanted. And they waited right before, the week basically before the trial, where juror stuff was already sent out about it, before they basically said, nope, this isn't enough time, so we're going to waive the right to a speedy trial. So that was their other reason for you to donate. But this is what you gave for, because they weren't being reimbursed, and you were giving money because they wanted to have a speedy trial and they needed all of these expert witnesses right now. So now they didn't have the speedy trial and they got reimbursed. So here, Abby and Libby, memorialpark.org. I put this in my community post. I have the link in my community post. Please, if you have a YouTube channel, please share this. Here's the other thing. This would help the Abby and Libby Fund. The other thing you can donate to help victims is I started a National Center for Missing and Exploited Children, Justice Serve Daily page. I have the link on there. It goes directly to the National Center for Missing and Exploited Children site goes missingkids.org. This is when you set up the page, give.missingkids.org/justice served daily. When you go in there, this money does not go directly to me whatsoever. It goes straight to the National Center for Missing and Exploited Children. You can see their logo and stuff in it. It is their own site. You can go in there and click on donate. It keeps track of funds and stuff in there to help children who go missing, like Abby and Libby, who help children who've been exploited, like what Keegan Klein was doing, like what Anthony Schatz was doing. So here's our action. I will keep putting out facts clips and doing the live videos. And trust me, there are some missing kids cases and some cold cases I am working on to get out. I got to catch up. My stuff that went on delayed me in a lot of stuff I wanted to do, and I will catch up as fast as I can and get these stories out to you. But you guys know I'm passionate about stuff that happened with children. And instead of maybe donating to somebody who may not be telling you the truth, why don't you make a donation to the victims and the missing? I am not a monetized channel for a reason. Now, it's not because I'm rich. It's not because I have lots of money. It's definitely not because anybody who does a YouTube channel, we have expenses. We have all that. I've had one time that I had, 4 people who went and used my, I don't even know what Cash App, and sent me a tip of some money for Cash App to help me with documents I get, because the stuff ends up expensive. I get that. I've helped people who needed help in burying their children. We've helped donate directly to it before. I've helped to do memorials for them and buying flowers and doing releases and doing all kinds of stuff for it. But please, if you're going to donate to the victims. Help the victims. Abby and Libby memorialpark.org. Go, if you ride a motorcycle, go to the ride. I'm sure you can donate and just be hanging out there too. Thought about it myself, actually. If not, click on donate, make a donation. And another option that I will keep this, I'm keeping this open for a while, but National Center for Missing and Exploited Children. Let's protect our kids. This stuff it's not going to me. I'm not sitting here. I'm not doing this stuff to make money. I'm doing this stuff to make a difference. And please, it's in my community post. I have the links for both the National Center for Missing and Exploited Children. I've got the link for Abby and Libby in there, so that people can give to either one. Share this like people shared the donate to Richard Allen. Right? Can we share this like that? Can we raise $40,000 for victims? I think we can. Yep, you can buy a brick. Actually, CJK, I'm thinking of maybe getting a brick that says Justice Served Daily on it to represent our justice warriors and our channels and stuff like that on it. For, people know that we're working hard for them. So please, and thank you again for you guys being here. Please hit like, please subscribe. The subscriptions are what mean a lot to me. If there is a question or information you've heard about the DELPHI show on any of my shows, and you think it should be pointed out, or maybe a question you have and you want me to be able to do a clip, a short video on it, and send that out about the DELPHI case, please ask me the question underneath this channel. Just put some comments in there. Let me know. I'll create that. We'll work on that. I'll let you know when the upcoming Richard Allen video is going to come in, because I think that's important. And then we have some missing kid cases that are cold cases that we need help with. I'm also going to throw this out there. I put some information about the FBI warnings about kids and stuff like that. Guys, this is the most dangerous time for kids, is during the summer. They know kids are not in school and they're home. Know what your kids are doing. Know what they're on their phones. Know what they're on their computers. Talk to them about the dangers of that. Tell them about people faking to be kids to talk to them, and about the situations they can get into. So I appreciate all of you coming here. It means so much to me that you guys watch and share and everything. I can't tell you enough. I have missed you guys a lot. I'm still struggling, but I'm trying to push forward every day. And I can't do it without you. So I hope everybody that can go to the ride Saturday goes, and make sure that we can get justice for Abby and Libby, and answers for the Flora 4, and help these new missing kids that are missing in Indiana, which there's a lot, and more keep popping up every day. Thank you guys so much, and thank you for making sure that justice is served daily. Goodbye, everybody.